and welcome. Today we'll be talking about IDEA Part B. Specifically, we'll break down the parts of the law related to manifestation and disciplinary action for children with disabilities. When behavior requires intervention, a series of events may happen. One of the major things is determining if the child's behavior is a manifestation of their disability, or in other words, an expression of their disability. IDEA is very clear in stating that during any proceedings, such as a manifestation hearing, the child is to excuse me, the child is to remain in their current placement or be assigned to a public school program given parental consent. Key words there, given parental consent. So understand that that is one of your rights as a parent to be a part of that decision. IDEA also says that school personnel have the authority to change the placement of a child with a disability to an alternative setting if their behavior violates a code of student conduct. They may suspend the child for up to 10 school days, which is to the same extent that can be applied to non-disabled students. In the event that behavior is deemed not to be a manifestation of the child's disability, and school personnel are seeking alternative placement beyond 10 days, again, they can follow the same disciplinary procedures as with students without disabilities. In any case, a child who is removed from their current placement must continue to receive educational services to enable them to be successful in general education. They are entitled under IDEA to receive a functional behavioral assessment and behavioral intervention services to prevent reoccurrence regardless of whether it's determined to be a manifestation of their disability or not. If a child's placement changes as a result of a student conduct violation, the local educational agency, parent, and the IEP team needs to meet to collaboratively determine if that behavior was a direct result of the child's disability or if the behavior was a direct result of failure to implement the IEP appropriately. If the group decides that it was in fact a manifestation of disability, IDEA requires that the IEP team conduct a functional behavioral assessment, or FBA, and implement a behavioral intervention plan if they have not done so previously. If a plan already existed, they need to determine appropriate modifications. IDEA states that the child should return to their original placement following the decision, unless the parent and local educational agency agree to change the placement as part of that behavioral intervention plan. Understand as a parent that it is your right to be part of these meetings and decisions, so don't be afraid to voice any concerns that you might have here. It should be a collaborative process. Regardless of whether the behavior is determined to be a manifestation or not, the child may be moved to an interim alternative educational setting for up to 45 days if the child carries or possesses weapons to or at school, knowingly possesses or uses illegal drugs, sells or solicits the sale of controlled substance on school property, or has inflicted serious bodily injury upon another person while at school. IDEA requires that the school inform parents of disciplinary action the same day it occurs, and that the school provide a copy of procedural safeguards. If you haven't watched the previous video on IEPs yet, procedural safeguards contain a lot of parent rights and resources, so be sure to thoroughly review them. If a parent disagrees with the placement or a manifestation decision, they can file an appeal. The school may also request a hearing if they feel that keeping the current placement puts others at risk for injury. A hearing officer may then return the child to the placement from which they were removed, or they may order a change to an interim placement for 45 days if they agree that there is a risk for harm in the current placement. In that case, the child would remain in the interim replacement until the hearing officer has made that final placement decision or until the 45-day period expired. IDEA requires that the hearing itself take place within 20 school days of the behavior occurring. The final determination then has to be made within 10 days of the hearing. If the school was aware that the child had a disability prior to the behavior occurring, but they didn't qualify for special education and services, the student is still afforded the same protections under this law. IDEA states that schools are deemed to have prior knowledge if the parent or teacher had submitted written concerns to supervisory or administrative personnel that the child may need special education, if the child requested, if the parent requested an evaluation, or if the teacher or school personnel had previously expressed concern regarding a pattern of behavior directly to the special education director or any other supervisory personnel. If the parent, excuse me, if the parent refused an evaluation or services, or if the evaluation was found that the child didn't have a disability, the school would not be deemed to have prior knowledge, which would mean that the child could be disciplined similarly to children without disabilities. Now, sometimes requests for initial evaluations are made in response to behavioral occurrences. If a request is made during the disciplinary time period, IDEA states that the evaluation should be expedited. If it's determined then that the child has a disability, the child should be granted services and remain in their current placement as appropriate. One last point I want to make here. IDEA specifically says that if the law says that the law doesn't protect against nor encourage schools not to report crimes to the appropriate authority, meaning that school has every right to call the authorities if a serious crime was committed despite the child's disability status. Now, this doesn't, excuse me, I'm sorry. Now, this doesn't mean that they will, but they certainly can. And the law obligates the reporting agency to turn over copies of the child's IEP, as well as any disciplinary reports for consideration. IDEA says that states may require schools to include disciplinary records in their student records. They should reflect any current or previous actions taken, a description of behaviors engaged in by the child, and any other information relevant to the safety of the child or others. Furthermore, if the child transfers to another school, their records should include both the IEP and that disciplinary information. In regards to suspension and expulsion rates, IDEA requires that states regularly examine data, including disaggregated by race and ethnicity, or discrepancies in rates of long-term suspension and expulsion of students with disabilities in comparison to non-disabled students. If discrepancies exist, meaning if one group, either disabled or non-disabled, was expelled or suspended at higher rates than the other, IDEA requires that those states revise policies, procedures, and practices that relate to the development and implementation of IEPs, the use of positive behavioral interventions and supports, as well as procedural safeguards. This part of the law helps to ensure fair and equal treatment for children with disabilities. Finally, there's a clause in Part B that states schools cannot require a medication as a condition for attending school or being evaluated or given services. It's your right as a parent to make medical decisions on behalf of your child, and the school may not use that against you. That concludes our review on manifestation and disciplinary action. There's one more video on the series where we'll talk about what IDEA says about the mediation process, and then we'll be done with Part B. Thank you so much for joining me.